Circuit Court is back in session. You may be seated.
I'll give us Tisdale's present, our counsel present, the jury's outside the court. Okay.
So, in all fairness, we didn't even really know that we were going to be arguing relevance. Mr. Backwell's been saying he has an issue with it coming in underneath business records all day. And the first time I hear something about relevance is just when he's talking to you. It's not only should it come in underneath business records, it should also come in underneath 90.803 subsection 8, the public records and reports. Just so you can kind of see the whole context on how we're picturing it, the state had Detective Wentz, Graham King, Lieutenant Dietrich, and Deputy Bennett all testifying about procedures and policies of making a traffic stop versus felony stop. Without a doubt, they've certainly opened up the door, and even if they hadn't, this case is about a traffic stop. And how Sergeant Morales performed the traffic stop and issues surrounding that are all absolutely relevant. This was a traffic stop gone bad. So how it's proper to do a traffic stop is absolutely relevant. In addition to the main charge that they have, they've also charged with fleeing and eluding, which is why we included the motor vehicle pursuit policy because of the case. We're not, and perhaps if you would have asked, I could have narrowed it down for him. I thought it was obvious. We're not asking the jury to read all 17 pages or intending to read all 17 pages, whatever it may be, to the jury. We're looking specifically at the portions surrounding policies and procedures for making a traffic stop and also the motor vehicle pursuit policy. It's also relevant to the defense's theory of the case, even in, since the beginning, this has been about how Mr. Tisdale was pursued by Sergeant Morales, and it's relevant to the context of that. The only other thing I want to add in is that he says this is policies made by faceless bureaucrats. Well, Sergeant Morales was part of the training unit, and he was also submitting changes to these policies and procedures. So that's not a very fair characterization of how and why this was created.
Back it up.
So Detective Wentz' description as to how a traffic stop is conducted was relevant in the context, and this is kind of how you make a relevancy argument. It was relevant in the context that, number one, it explained what 10 codes, but in the context of the dispatch tape, it explained what 10 codes were. It explained what the language meant when he called out 1050. It explained how the officer identifies himself. It explained how the officer provides a location. It explained how the officer gives a vehicle description, all relevant and related to explain the dispatch tape. And that the reason, and of course I also needed to lay a predicate that I had established that the dispatch tape is a business record as well as non-hearsay. I was laying predicates to establish the spontaneous nature of the transmissions, the reasons for the transmissions, that is, so everybody knew where they were, which is officer safety. These are not issues that go directly into the policies and procedures. Again, they haven't shown you anything in particular in that policy that they want to offer. If you look at it, it goes on for 10 pages with regard, I don't remember if that's the 7 or the 10 page one, but 7 or 10 pages about tons of things that have nothing to do with this case. Now he says to you, well, we're going to put it into evidence, but we don't expect the jury to read it. Well, when you put something into evidence, you should assume the jury is going to look at it. And so, again, I think that, just on a 403 argument, not even a 402, 401 argument, it's not relevant. Now, let's talk about the fleeing and eluding policy. We haven't gotten to this yet. I guess I anticipate it's coming, and apparently I'm supposed to tip them off when I'm going to make an argument, but fleeing and eluding, Judge, even if we were to concede, and I am not conceding any way, shape, or form, that his efforts to stop the defendant were illegal. That is, were not based upon any founded suspicion or probable cause for a traffic stop. Guess what? He can't flee anyways. He's still in violation of fleeing and eluding. His conduct is still illegal. I got case law, tons of case law on that point. So the fleeing and eluding policy is utterly irrelevant. It's all utterly irrelevant. But again, I go back to very simple, put them to the test. Make them specify what material fact and issue, whether, they say it's all about the stop. Well, here's the deal. I didn't play his statement. And I didn't play his statement for a very particular strategic reason, because I want him to get on the stand and say that himself. That's up to him. If he does, could this potentially become relevant? Maybe. I don't know. But at this stage of the proceedings, what is the defense? What Mr. Glenn has said, which is not evidence in his opening, is something about spontaneous and sudden. What does that have to do with the traffic stop policies? How does the traffic stop policies tend to prove or disprove the sudden, spontaneous nature of this act? It doesn't. We're not. It may be relevant. I just want to hear the argument. I'm going to agree if I would stipulate. But I don't see it, Judge. I don't see anything here that's relevant.
Bishop, any other comment?
Only other comment I make is Detective Wentz specifically said that this traffic stop was done in conformity with the policies. It turns out that it's actually not. And for the state to try to prevent the defense from putting on a case is beyond me. And Judge, it could certainly, again, we have no problem redacting all those portions down. We don't need to include the other pages. We can black it out. And we can shorten it down to just the specific portions.
The defense seeks to introduce two different sets of documents. One is referred to as a 10-page general order from the St. Lucie County Sheriff's Office. Its effective date, according to the document, is January 15, 2009. It's policy and procedures to be used in St. Lucie County Sheriff's Office incidents of car pursuits or car chases. The second set of documents is a 7-page general order effective, according to the document, June 1st, 2005, that deals with policy and procedures of the St. Lucie County Sheriff's Office regarding the proper use of Sheriff's Office vehicles. I've read each policy and procedure. The state objects, arguing this is not relevant. They cite 3 cases, Department of Highway Safety and Motor Vehicle, State of Florida Department of Highway Patrol versus Stephen Pollack, P-O-L-L-A-C-K, 745 Southern 2nd, 446, 3rd District decision. Lozano versus State, 584 Southern 2nd, 19, 3rd District decision. And finally, Pitts versus State, 473 Southern 2nd, 1370, a 1st District decision. I've read each of those cases. Vince argues these documents are admissible. Now, whether they're admissible under a business record exception or some other provision of Chapter 90 under the Evidence Code is not the issue. Now, it's still this evidence still has to be relevant before it's admissible under either business record exception or public document exception under the Evidence Code. Mr. Manship, what's the issue or fact that these documents tend to prove or disprove? In other words, what do they prove or disprove that's an issue in this case?
It does go to the defense theory of the case as to lack of premeditation. And premeditation and intent is something that the state is trying to prove. And these go to towards disproving that.
How so?
Well, as far as Mr. Tisdale's reactions towards Sergeant Morales and how he perceived him, and whether or not he was, if an officer is not acting within their policies and procedures, well, that may certainly have an effect on Mr. Tisdale, on how he perceives and how he thinks, and ultimately his reaction or overreaction, and that goes towards disproving his intent to commit first-degree murder of a law enforcement officer. It goes to the ultimate issue in this case, and it's the defense theory.
Well, I agree that's one of the ultimate issues, to be sure, but how does these introduction of these policies and procedures prove or disprove that? I'm not following that, how that disproves he had a premeditated intent.
It was, I'd just be repeating myself, Judge. It has to do with, I can't state it any differently than I just did. I'm sorry that I'm not getting the point across. This goes directly to the defense's theory of the case as to how Mr. Tisdale perceived the actions and reactions of Sergeant Morales and whether or not Sergeant Morales is acting in conformity with the stop procedure. And possibly Sergeant Morales wasn't acting within the stop procedure or the
Well, don't these cases say that that's what makes them inadmissible?
Well, those are...
In other words, however Mr. Tisdale perceived Sergeant Morales is how Mr. Tisdale perceived him. How would it affect Mr. Tisdale's perception of Sergeant Morales and his actions if these documents are introduced into evidence?
So that the jury can see how Detective Wentz said this is how a traffic stop is absolutely supposed to happen. He did all the correct things. Well, it turns out that he didn't. And it's important for the jury to be able to hear that.
Well, wait a minute now. I thought this went to disprove the lack of premeditation.
Yes, sir.
Because Sergeant Morales didn't follow the procedure on a traffic stop?
That directly ties into lack of premeditation. It directly ties into
That's what
how Mr. Tisdale is perceiving and how he is thinking.
Do you have any authority that supports your position?
No, sir, not this time. Like I said, I wasn't even anticipating arguing this like this today. Mr. Backall was talking about business records all morning, and now I just hear relevancy. So I'm going to certainly look and try to find you some.
Well, I'll give you time.
Morning, sir.
I'll give you time if you want some. What else do you all wish to talk? I'll give him time to submit any authority to me. But what else do you all wish to talk about?
I did just file, and you probably won't see it, which is, I brought you a paper copy. I already gave a copy to you as well. May I approach?
Yes, sir.
It's just about Natasha Powers. It's our expert that's going to be testifying tomorrow. So I just want to give you a copy of that, just so you know, that doesn't have to do with deposition. He can ask whatever he wants. It's just limiting him from going into impermissible, irrelevant things during his cross-examination, as he was alluding to the other day. And then we were also thinking about maybe doing jury instructions today. I'm just saying that, Judge. I wasn't necessarily asking you to rule on that. What I just filed right now. I was just giving you a courtesy copy.
All right, I appreciate it.
Filed it during lunch.
Just let me take a look at it. Well, I'm a little bit of a disadvantage because I don't know what she's going to testify to or what cross-examination, if any, the state intends to elicit from her. I guess we'll just wait and see. But she's going to be prepared to testify tomorrow?
Yes, sir.
Mr. Bagadol, you wish to comment on this?
Well, I can say that there's just tons of information out there about this witness, but more specifically, we're now receiving information that there could be misrepresentations in her CV, and certainly that's going to be fertile ground. I agree that potentially, from a character evidence standpoint, some of this misconduct on her part, these specific bad acts, may not be admissible in court. As the court has indicated, we'll have to cross that bridge when we come to it. I will say this, Judge, again, as I've been indicating since the beginning, this witness was listed on September 4th. She has now theoretically been made available for deposition sometime. I still don't have a time. I've talked to the court reporter, and she's graciously agreed to stay with us and conduct the deposition. Here's my problem. As are you, I'm in the dark. I have no idea what this witness is going to say. All I've been told is procedures, policies, procedures. The court reporter has informed me that for every approximately hour of deposition, it takes her 3 hours to transcribe the deposition. Is that correct?
Yes.
So I think it's pretty evident I talk a lot, and I'm concerned that I can't imagine spending less than 2 hours with her, and now I'm putting the court reporter in a position where she's got to stay up 6 hours after whenever the deposition starts, which I still don't know. And then I would like to have the deposition. I'd like to review the deposition. I'd like to outline the deposition, and I'd like to have my cross-examination prepared. Here's what I'm asking. I'm asking simply that if she testifies on direct, that I can have a break after her direct examination to complete that task so that I'm prepared to effectively cross-examine her. I have a real sneaking suspicion that I'm going to have a motion for you in the morning that her testimony is irrelevant. But I'm guessing. If to tell us now, maybe we could argue it at this point in time. But what I'm asking is very simply that once the direct is done, I'd be given an opportunity to prepare my cross-examination so that the court reporter isn't required to, spend all night doing the depo.
Okay. Defense wish to comment?
Fine. I have no problem with that.
Okay, if you'll just remind me, I'll give you a break after the direct, if any, and you can do what you need to do. But just remind me, because I may forget. Or do y'all want to discuss jury instructions?
Sure.
Okay. I don't know if y'all have a proposed package or not. Y'all have a proposed package? If you don't, it's all right. I'm just
No, I
asking.
don't. I thought we were just going to go through the book. I don't have anything with me.
Okay. That's all right. Well, I don't have an instruction book here in front of me, I don't think. I got an older one, maybe I can just use that. Yeah, I got the rule book, but that doesn't have the instructions in it. I think I got what I need here. All right, I'll give, of course, the closing argument instruction 2.7. By rule now, it's state defense and then the state. I won't pin you all down as to how much time you're requesting. We can talk about that later. State have any objection to that being read?
I do not.
Defense? Okay. Then I will read 3.1, the introduction to final instructions. State have any objection to that being read?
I do not.
Defense?
I do not.
I will read 3.2, the statement of charge instruction. State have any objection to that being read?
No, sir.
Defense?
I agree.
Okay, now, as you all know, there's an introduction to homicide instructions. Y'all are familiar with the introduction to homicide instructions.
7.1.
Yeah, it's either 7.1 or 7.2. Here it is, yeah, 7.1, thank you. State have any objection to that being read?
No, sir.
Defense?
No objection.
All right. I think 7.2 will be necessary. State have any objection to 7.2?
No, obviously we'd suggest some modifications we're going to need to make.
Right. I don't think under that instruction we need transfer intent.
I agree.
Defense agree we don't need transferred intent?
I agree with that, Judge.
No, there's felony murder first degree under 7.3, but I'm not sure that's needed, at least so far, under the facts of this case. Is anybody requesting 7.3?
Oh, 7.3?
Felony murder.
Oh, no, I'm not done. I was still on the first degree murder
Oh.
section. There's, obviously we're requesting we would probably put the firearm language somewhere after that. We're also requesting the law enforcement engage in lawful performance of duties. And I would ask for immediately following that, an instruction on the following statute, Your Honor. 316.1935, subsection 1, which is fleeing and eluding and reads as follows. It is unlawful for the operator of any vehicle having knowledge that he or she has been ordered to stop such vehicle by a duly authorized law enforcement officer, willfully to refuse or fail to stop the vehicle in compliance with such order, or having stopped and knowing compliance with such order, willfully to flee and attempt to elude the officer, and a person who violates this subset. I don't need that part, but so what I'm looking for is, Sergeant, the defense has made some issue of the fact that Sergeant Morales did not have his license siren on, and while the defendant is charged with fleeing and eluding license siren, that offense is predicated on the events that followed the killing of Sergeant Gary Morales. This particular section, which is a legal reading, or is a correct interpretation of the law, is an exact quote of the law, would show that Sergeant Morales was engaged in the lawful execution of his duties. It's an element of the offense for which he has been charged. I indicted him specifically for murdering a law enforcement officer. So I would ask that that instruction, and I'll get it out of the book somewhere, be inserted after the language relative to a law enforcement officer.
Let me just suggest this. Why don't y'all, let's go over the standard things I think we can agree on, and I'll come back and talk to you about the substantive instructions. For example, under this instruction, there's a paragraph that says there are two ways in which a person may be convicted of first-degree murder. One is known as premeditated murder, the other is known as felony murder. Now, it doesn't sound like the state's traveling under the felony murder theory, so I'm not sure that's necessary. But let me come back to that. These others I think we can agree on. If y'all just give me a minute, I'll get to those. After y'all are finished with closing argument, I'll read 2.07, I'll read 2.7 prior to y'all giving closing argument, and then when you're done, give me a minute here. I'll read 3.7, plea of not guilty, reasonable doubt, and burden of proof instruction. State have any objection to that being read?
No, sir.
Defense?
No, sir.
I'll also read 3.9, weighing the evidence, the first two paragraphs, and depending on what the testimony and evidence is, some of the others are applicable, some are not. But we can talk about that after all the evidence has been presented. Any objection to 3.9 being read from the state?
No. Sir?
Defense?
No.
I anticipate reading 3.9A, expert witness, as there has been at least one expert witness tendered to the jury. State have any objection to that being read?
3.9A is defense not testifying.
Mine's an old book. It must be,
Oh, I see.
it must be misnumbered.
Okay. Expert witness is
Isn't that included in 3.9?
it's included in 3.9 now, correct?
Okay, I've got an old book. So. Okay. Now, depending on what happens, if the defendant testifies, I'll read the defendant testifying instruction. If he elects not to, I'm required to read the defendant not testifying instruction, either paragraph or both, depending on the defense request. So we'll just have to see how the evidence plays out there. There hasn't been any to date, any evidence of the defendant's, well, there was one alleged statement of the defendant presented, so I'll give the defendant's statement instruction if either side requests it.
I'm not requesting it.
Defense?
I'm not requesting it.
Okay. I'll read rules for deliberation in its entirety. State have any objection to that being read?
No, sir.
Defense?
No, sir.
I'll read the cautionary instruction. State have any objection to that being read?
No objection.
Defense?
No objection.
I'll read the verdict instruction. If there are lessers, and I anticipate there will be, I'll read all three paragraphs. State have any objection to all three being read if there's lessers?
No objection.
Defense?
No objection.
I'll also read single defendant, multiple counts, as there is more than one count alleged. State have any objection to that being read?
No, Your Honor.
Defense?
No objection.
I'll read the submitting the case to the jury instruction. I'll also, if there's lessers, we'll read the lesser included instruction. All right, why don't y'all, if State, does my print up the proposed instructions on homicide and the lessers and on the ag assault.
If I could just get some guidance on lessers that the defense is seeking.
You want to give them an idea of what lessers, I mean, under ag assault would be simple assault, I think, but
Which kind? What kind? All category one.
Any of them.
All category one.
All category one, okay.
Okay. So if you'll print those up, we could, it'd be a little bit easier to go through which ones we need to modify or not.
Any other lessons?
On each count, in category 1 to 5.
You want all category 1s, all counts?
If either side requests it, and they're category 1 offenses, they must be given.
No objection.
Now, if y'all want any category 2s, we can talk about that before we formalize everything, but there may be, there may not be. Okay, if y'all do that, we'll take a look at the substantive instructions before we formalize it. Those others are pretty standard. Okay, anything else we need?
No, I'll have them out tonight as I'm waiting for the depot to begin whenever we get that scheduled.
And Mr. Manship, if there's any authority you want me to take a look at, bring it over first thing in the morning, I'll be happy to look at it.
Absolutely.
Okay? Okay. Thank you all very much. We'll see you at 8:45 a.m., please.
I was going to give you a heads up, but we're not for the...
It seems like.
Use my French girl.
She was landed in Fort Lauderdale. Got her.
I thought it was supposed to come.
Well, now she's got her.
Miami wasn't available?
It's basically 2 hours away. I was close to an hour ago. She was taking the car and going straight up.
All right, so we want to plan on 4 o'clock.
Maybe a little optimistic, but I'll be giving you an update before then.
Okay. Where are we going to do it?
I mean, I'm more comfortable in my house,
Yeah, no.
but we can come over